The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about some common life events that require a review of your estate plan. So let's dive right in. When you get married, that's when most people have their first estate plan made. You want to provide for your spouse to make sure that everything goes smoothly for them when you pass away. You also want to make sure that they're added on your life insurance and retirement accounts. When you buy your first home, it may be appropriate to have a revocable living trust as your primary estate planning vehicle. When you own any real estate outside of a trust, your estate has to go through a probate case, which can be costly, stressful, and time-consuming for your loved ones. So when you buy your first home, you should talk to an attorney before you actually close the deal, and they can create a revocable living trust for you and put the home in a trust as opposed to being owned in your individual name, and this will cause probate to become unnecessary and make things much simpler for your loved ones when you pass away. Having a child. So anytime you have a child, it's worth checking in with your lawyer to make sure that you don't need to update your estate plan. If you already have an estate plan, it should provide for any children that you have in the future. So you probably won't actually need to update the documents, but you should at least check in with your lawyer. And what you'll definitely want to do is make sure that you add the child as a beneficiary on your life insurance and retirement accounts. If you don't have an estate plan, this is really an important time to get one because you want to make sure you provide for their financial security should something happen to you. Make sure that the process is smooth and they get the maximum amount of your assets as quickly as possible if you were to pass away. And probably most importantly, name who you would like to serve as guardian if something were to happen to you. When your children reach adulthood is the next time you want to think about updating your estate plan. The reason for this is prior to your children reaching adulthood, you probably have friends or siblings or even parents named as your executor or trustee or power of attorney. And when your children reach the age where you feel they're responsible enough to serve those roles, it makes sense to add them to be the people that serve in those roles rather than your friends. If you get a divorce, you want to immediately update your estate plan probably during the divorce. You don't want your ex to gain control of your assets if you pass or become mentally disabled, especially if you have minor children. If you don't have a proper estate plan, it's very easy for your ex, as the guardian of those minor children, to just have all of your assets go to them rather than have someone you trust disperse those assets for the children's benefit. If you acquire new major assets, you may want to talk to an attorney to make sure that your estate plan isn't going to be subject to estate tax. The estate tax exemption in Illinois is $4 million, but this includes life insurance death benefits, which can be $1 million or a couple million. So if you have life insurance, it's pretty easy to go above the $4 million estate tax threshold. If you have more than $4 million in your estate, you're going to be subject to Illinois estate tax unless you work with an attorney to do some estate planning to minimize that estate tax. So if you haven't been over the estate tax exemption in the past, but you're acquiring a significant new asset, that would be the time to talk to an attorney about doing some estate tax planning. If you already have done estate tax planning, but you shift around your asset structure, acquire new assets, sell your assets, it's probably a good idea to regularly review your estate tax planning to make sure that you are still doing the optimal thing to minimize estate tax considering your new asset structure. If you want to change the distribution of your assets when you pass, so if you acquire a specific new asset like a home or a piece of property or a gun collection or a motorcycle that you want to go to a specific person, you can update your estate plan to provide that this specific asset goes to this specific person. Or if you want to change who's going to inherit, let's say you want part of your assets to go to a charity or church, you can make that change. So if you just want everything to go to your spouse and then to your children and then to your grandchildren, if your spouse or one of your children is not living, then your original estate plan should probably provide for that already. But anytime you want to add a beneficiary or you have a falling out with a beneficiary, that would be a good time to check with an attorney and update your estate plan. Similarly, if you want to change who the fiduciaries are in your estate plan. Your fiduciaries are the executor, the trustee, the powers of attorney, the people making major decisions if you're unable to do so either because of mental illness or death. That is a really common time to update your estate plan. And this is generally if you drift apart with or have a falling out or there's someone more appropriate than the people you've named already. And again, this is when your children reach the age that you feel they're responsible to hold these roles, as opposed to whoever you've originally named. That's a good time to do it, even if you haven't had a falling out with somebody. Finally, when you're ready to plan for long-term care. If you have a proper estate plan, you can be eligible for Medicaid for long-term care without spending down all of your existing assets. You can make sure that the assets make it to the next generation rather than being spent to provide for long-term care. The trick is you've got to do this at least 5 years prior to applying for Medicaid for long-term care. Otherwise, any planning won't be effective, and it's very problematic, and there's not much you can do within that 5-year window prior to applying for Medicaid. So you've got to make sure you plan a little bit in advance for long-term care. But as you start seeing that in your future, that as soon as possible, start talking to an attorney to take a look at your estate plan and seeing what you can do to plan for that. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. Please subscribe to us wherever you listen to your podcasts or watch your videos. And if you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.